something. You're all experienced in these areas. You work professionally in these areas, so we're going to jump into a bit more of strategic and detailed analysis. What I'd love from you is interruptions. So if you could possibly raise your hand and interrupt as we go along, it will keep you all awake, that's for sure, and I think we can get more out of it. So to get the ball rolling, let's start with the first issue we want to talk about, which is whether trusts and foundations fit in the strategy for Malta developing as a financial center. What is their role? And if there's anybody who wants us to say what a trust is and what a foundation is, obviously, now's the time to interrupt. But if not, we can move on, and we'll start from an angle of the analysis, and Annalise will start explaining what she's seeing in terms of the contribution to the private and family context.
Good afternoon, everyone. So I speak as a notary public, so obviously I deal a lot with the private and family planning context. And we're trying to analyze how trusts and foundations really contribute to discussion and contribute to opportunities for planners and practitioners like ourselves. So it is my understanding that obviously these tools, within the context of the already elaborate civil law we work in, so trusts and foundations, weren't grafted into barren legal grounds. We already have a civil law context which is very robust based on the Code Napoleon, and we were aware of it for legal practitioners in the room. We've always used them since time immemorial, but having trusts and having foundations has added undoubtedly flexibility and greater estate planning opportunities. I mean, nowadays we can focus and offer solutions both inter vivos and causa mortis to clients that are more extensive and more dynamic in the remit. By inter vivos, I mean during the lifetime of a person, and by causa mortis, obviously it links to succession opportunities. Now, a trust and a foundation doesn't suit everyone's needs. Obviously, it is the particular situation of particular clients which dictates, I say, a moral obligation from a practitioner to offer these opportunities and these possibilities to clients. So particularly with vulnerable family members, and I speak of disabled people, for example, some family context with minor children, and either parent having issues with the other parent taking care of the assets entrusted to a minor in a potential demise, for example. So vulnerable family members, provided we use these tools in the proper way, we could offer a wide plethora of solutions. For example, think of separations, personal separations. The most common reason for procrastination in determining and concluding a personal separation would be the determination of the biggest asset being the matrimonial home, many times, right? If we put this in a trust, we could go on to the personal separation and keep the asset in common ownership in a trust. So it offers solutions. This is the major point I want to make. Obviously, we need constant in-depth study in the civil law issues. Trusts and foundations do not exist in a vacuum, so we need to analyze trusts and foundations vis-a-vis the mandatory provisions in our law, so forced heirship, matrimonial regime. So these are all the context within which these tools operate. From a private law scenario, it is not particularly considered an employment generator, nor a tax generator, so we're not here generating as such new business. We are only offering more tools to existing practitioners, okay? However, what I want to say, even though by saying it is not an employment generator, not a tax generator, we might say there is no economic rationale behind these tools, having the right tools in place would lead to an economic benefit in the planning process of many individuals, because we know how much money and how much assets go dissipated because of improper planning. So even though it's not, let's say, an employment generator or not a tax generator, there is an economic value to proper private context planning. And obviously, it's something that is an evolution, okay? These laws need constant legislative support. So we need to rethink and fine-tune the laws on a regular basis. And I think that's the good thing of seminars like these, so that we can discuss and see what are the major requirements to render these instruments more amenable to practitioners and also more attractive to clients as such.
Thank you, Annalise. Your point about solutions is very, very relevant in the commercial context, which I'll just address in brief. We find trusts as oxygen to the system when we're dealing with complex commercial security structures, for instance, and we find our banks are starting to use trusts as part of the security offering. So typically when a borrower borrows money from a bank, the bank takes a hypothec or a pledge. Nowadays, we're starting to see that some banks are actually putting property, accepting to take property under trust in order to create more protection for the borrower, should there be an enforcement event, because they could get a proper market price as opposed to enforcing a hypothec through the courts. The courts take a long time, they cost a lot of money, and therefore the trust could actually provide a very reasonable solution. And then we also find security being used in private structures where you have shareholder agreements or arrangements about shares in a company. And so you can put a trust holding some shares while the buyer is paying the seller, or while a transaction is taking place, and you want to wait for a transaction to take place before the shares become yours. So, we've found that in the commercial context, there is a wonderful opportunity with trust in the legal system. We found it's also useful with division of property. Under civil law systems, you find that we have a very rigid system of co-ownership, where people have to consent to everything you want to do with your co-owners. With a trust, you have a trustee who has to decide in the interest of all the co-owners and can take decisions without anyone blocking. The biggest problem we have in a small society is the one vote you need, the one consent you need, and it blocks everything, and you find a lot of derelict properties because you can't actually take a decision about them. We're now starting to see that the retirement and pensions area is working because we have trust in our system. By a quirk of politics, tax, call it what you like, there was a problem with Guernsey in relation to QROPs, and everybody started looking at Malta as a solution. And because we had trusts, they could shift the structures that existed at the time in Guernsey and could continue them in Malta without any particular problems. Had we not had trust, and I remember the time in our country when we didn't, people would say, can we set up a trust? Then we'd say, no, we don't know what they are, we don't know what they do, and now the situation has changed radically. We can use them in funds, but for some reason, trusts have not been used in funds at all. We use CCAVs, open-ended investment companies, but not trusts. We have used trusts in the security context for collateral when you need to create collateral for a prime broker, for instance, or a trading parallel. Clearly, I agree with Annalise, we need in-depth study because you can't use trusts properly unless you know how they work. They are clearly saving costs because they're smooth, they're fast, they're easy, and they save costs in the creation of structures and security. And we have a registration system of hypothecs which is based on ad valorem calculation. So if you have a €5 million hypothec, it's going to cost you, say, €5,000 to register the hypothec, and that's at the public registry. And then you've got the notaries and the lawyers, while with the security trust it doesn't cost anything and it's tax neutral. Again, it is not an employment or tax generator for the country, so the motivation of this is not to have employment or tax generation, but to oil the system in terms of the way it works. We do need some legislative support in streamlining, and hopefully that will come soon. And the point I'm making here is that it has long been recognized that the common law countries in the world are the most efficient economically and financially because they have elements like trust in their law. And I can certainly confirm that since trusts have come into our system, there has been a massive advance in this area. We'll now look at it from a different angle, which is the international context, and Malcolm will be looking at that.
Well, good afternoon. I'm an international trust practitioner, obviously with corporate and all the other things that you would expect in that type of business dealing with private clients. The first thing I wanted to do is look at the international players to give you some perspective of what's happened in the last 10 years or so, since the introduction of the Trust Act in 2005. Originally, when we came to Malta in 2003, really the only office that had an international footprint was Bleven Franks, with very much a southern Mediterranean footprint. Now, if you look at the people that are in Malta, you have 12 other names there. With my 25 years in a number of jurisdictions, these names are very familiar to me. And they cover organizations with very much an international footprint, with some of them 17 and 19 offices. Some of them represent some of the largest players in the international and corporate arena. And also, if you look at the jurisdictions where they come from, they come from jurisdictions which we would have normally associated in the last 20 years with the international financial centers. So we've done quite well to bring people with experience and with profile from these jurisdictions. As I say, 12 names there. And they are almost the who's who of the international financial centers. So that's just a little takeaway. I do have to apologize if I've left anybody out. This is my slide, and I went through the MFSA's list. And I knew Heritage was here as a management company, but I didn't know they brought their trust company as well. So I learned a few things going through myself. So I hope that would be an interesting slide for you. Now, if you go back. The second point on this slide is in relation to something Max has already mentioned in relation to pension and retirement, and the QROPs, which are Qualified Retirement Pension Schemes. Before Guernsey had its issues, we were already developing a business here. We already had practitioners based here, and we were already looking like an interesting addition to the QROP jurisdictions. We offered, like we do in the trust arena and like we do in so many of the other arenas, such as funds, we were offering a very compliant and regulated jurisdiction, where it probably maybe many of you won't realize that Guernsey was somewhat of an unregulated, self-regulated environment. So this was offering a different solution. We were also looking for a solution that was more tax compliant, which is another advantage that Malta was offering. This has meant that this area has actually expanded probably faster than Malta would have liked, with a number of offices based here. Obviously, we've got to tie in the international businesses coming here with the resources and the adaptation of the resources. This business is now, there's 6 or 7 practitioners here, and they do have quite reasonably sized offices in a very short space of time. The other advantage on international context is the transfer of knowledge. Practitioners in Malta dealing with advisors from different jurisdictions. There's a transfer of knowledge probably both ways in relation to cross-border taxation and private international law. One of the advantages I've seen since I've been in Malta is the quality of the legal and accounting services. Got Malcolm in the front here looking right at me. But it is, it's very impressive compared to some of the islands that you deal with. There's a great depth, and obviously the university training, people going on to do MBAs, going on to go to Leiden, it makes a tremendous difference to the quality that you see on the island. Now, unlike the previous two, obviously generating employment and generating taxation, this industry is generating a lot of employment. We don't really have the proper statistics in this area because they dovetail with lots of other areas of financial services, but hopefully in the next 12 to 15 months we'll probably get some idea a little bit more on the statistical side. Taxation, obviously, because there's employment, you've got the employment taxes, and fortunately most, if not all, of the operators are making good levels of profit. So, even if they're foreign owned, you still get some contribution on taxation from their operating profits. The last point on the slide is something that is not new. Discussed with me when I first arrived on the island 10 years ago, Malta's approach being very much towards the onshore rather than the international aspect. So, the word offshore is something we've always stayed away from. Very much in vogue now and in context, probably more so than it ever has been in the last 10 years. And it's obviously something we have to be very, very aware of.
Thank you. Okay, so this gives you a quick review of the strategic approach of the country to it. I think on the whole we've gone for substance in the law, we've gone for substance in practice because every company has to have local operations. Education has developed tremendously around the subject. I would estimate, I don't know, but I would estimate, say, 250 people working among those 14 companies.
Yeah, probably over 200, yes.
Okay, and the Blevins Franks example, which you mentioned as the starting point, was a company which shifted a lot of international trusts on the other laws to be administered from Malta. And our legislation is very neutral to foreign law trusts being operating in Malta, and that was an important feature. There's no problem at all for a Jersey trust or a Guernsey trust or a Cayman trust being administered in Malta because Maltese law doesn't impinge on it in any way. And that was something that we were very careful about when creating the legislation. Okay, so moving on now to a bit more detail, and again, interrupt if you want to ask questions on a strategic level. We have some legislative projects which are in design or in thought, and then possibly, and with regard to trust, we actually have a bill which has been published. So just to give you a feel as to the kind of things that could potentially happen in relation to foundations, for instance. Foundations are very popular with voluntary organizations, charities. And there was an issue in relation to money laundering compliance. Malta's attention was drawn by the authorities when they were reviewing Malta, and there is a draft approach to the issue in terms of making voluntary organizations or charities compliant with the AML expectations. The industry hasn't grown noticeably, so it's not a problem with the country. But going forward, we obviously have to introduce legislation to extend the ambit of money laundering legislation. The second issue is that we have both private and purpose foundations. The private foundations are very similar to trusts with beneficiaries. The purpose foundations are the charitable or non-charitable purposes of a structure which is a fiduciary structure. So we look at these, for instance, for a securitization structure. The purpose is to hold shares until a securitization transaction is completed. It could hold a voting share in a company where you need a special voting power. Those kind of things can be done by foundations but not trusts. In the current legislation, there needs to be some fine-tuning on how these two types of foundations are dealt with. The purpose foundation is a perpetual foundation. The private foundation can't last for more than 100 years. So, you know, even on a simple thing like that, there is a big difference between the two. The reason why we have a strong law on foundations is because we have a very strong church hierarchy in Malta, and practically every institution of the Catholic Church in Malta is either a pious foundation, a marriage legacy, or an ecclesiastical entity. So there's a lot of law and practice in relation to foundations. These are more like purpose foundations, and therefore there's a lot written and decided upon by the courts on that subject, so there's a good source of precedent. We found, as the legislation has started operating, that there were many existing foundations that needed to be drawn out of the previous legislative scheme and as unregistered foundations, and therefore we need to address that issue to make sure we catch the whole community. We have registration procedures, and this we'll talk about a bit later, but a foundation can be registered like a company, and that was a legislative choice in the current law. You have a public registry, and you can register a foundation in that way. You don't need to go to a court, though there is a notarial functionality which will be explained a bit later. And finally, we've got the issue as to whether foundations can trade. And the answer is foundations should not trade. They are not meant to be trading organizations. It doesn't mean they can't be holding a company. It doesn't mean they can't be a passive fund, even an investment fund or a securitization vehicle, but they are not meant to get involved in trade. So that was a quick view of the foundation's potential law. With regard to trust, we actually have a bill, and Annalise will look at some elements.
Yes, we'll begin by looking a bit at the proposed, salient points in the bill. So there is a proposal for the perpetuity period for private trusts to be increased from 100 years to 125 years. So this would obviously exclude the charitable trusts, which are perpetual, and this reflects really the reality in the English legislation. All right? We're seeing a trend towards introducing limited settlor reserved powers. Particularly, these are examples of the type of powers we're looking at, so adding or removing trustees, protector beneficiaries, and appointing investment managers. There's also mention of this enforcer as a new office for a charitable purpose trust, and the minimum capital for authorized trustees to be increased to 25,000 euros. I mean, the reality is that authorized trustees are operating in a corporate structures companies. So currently the bill proposes an increase in the minimum capital to 25,000 euros and also a compulsory professional insurance for authorized trustees. There's also a new auditor reporting duties, and basically Malcolm can update us on the status of this process, which is currently underway. Correct me if I'm wrong.
Yep. No. Well, as I've spoken to Michelle recently, and she said there was an extensive feedback from the industry, and the MFSA are working through the comments that they've received. I don't know if, Michelle, you want to say any more?
I would say that in May we should be issuing a feedback statement and the draft bill revised.
There's also the proposal on the family trust, which Malcolm, I think, will be looking at even in relation to the family.
Yes, we'll get to that soon, but one point I'd like to make, which people sometimes miss, is that foundations have a board of administrators who are also authorized trustees, while trusts have trustees who are owners of the property. This difference between the two has emerged as something very relevant. With most organizations who suspect the intent and professionality of trustees, with a trustee, it is fairly difficult to change a trustee. While with foundations, it is very easy to change an administrator. So there's a shift in emphasis in terms of the powers of people involved in foundations as opposed to trusts. And in the previous slide, we mentioned that there was the issue of limited reserved powers for settlers. And the big concern was giving the power to a settler to remove a trustee. And this is one of the issues which is addressed in the legislation, mainly to make sure that settlers feel comfortable that if they are disagreeing with the trustee, they can actually intervene and do something about it. The way we do it today is we use a protector. And the protector is given powers, and the powers can be exercised through a protector because of the fear that a settler keeping control over the trust might run into those arguments we saw developing in Jersey relating to sham trusts. Although I don't think the theory of sham trust would apply here anyway, but it's a big issue in the trust industry. Does the trust remain valid if the settler keeps on controlling what is happening in the trust? When you jump into foundations, the issue doesn't arise at all, because the founder of a foundation can control a foundation, and therefore you change the dynamics once again over there. So moving on to family offices.
Can I just ask, what's the objective to increase the perpetuity period by another 20?
People are living longer, 3 generations are no longer fitting within 100 years, so you extend it to 125 to cater for 3 generations, basically. The perpetuity period avoids property being tied up for a period longer than the person creating it can foresee. That is the theoretical basis of the perpetuity period. And it releases property into the market.
Is that something that other jurisdictions domiciles are doing as well, or have done already, or will Malta be?
Yes, other countries like England are changing the period, but some countries who are more aggressive are actually eliminating it and coming out with the idea of a perpetual trust, even for the private sector. This is not something that was very popular in Malta when it got debated. The underlying concept in our law is to prohibit the tie-up of property, and that's the influence of the French Civil Code. You don't want to tie property up for too long. Otherwise, you kill the economic functionalities. That's what...
And the government wants the taxes.
And government wants the taxes. So that's what promoted the English to come in with the concept of a perpetuity period. You want to free property into the market at least once every 80 years, and now it's been extended to 125.
So a non-charitable purpose trust then?
A non-charitable purpose trust is not possible under Maltese law, but a purpose foundation which is not charitable is. Now, to give you an example of where the distinction between purpose and private becomes important, in the debates that have been going on, it appeared as an obvious loophole that if you allow a non-charitable purpose foundation to be perpetual, you could have a family interest involved in a non-charitable purpose foundation and have it perpetual. So one of the views that has been expressed is we need to look through the purpose foundations and determine whether they're actually promoting a private interest or not. And if they are promoting a private interest, then treat them as a private interest and apply the 100-year limit. So this is something which is showing the orientation of the legislative project. Don't allow things to look one way, take advantage of a rule, and really be something else. Go for the substance. If you are really, if you create a foundation, for instance, which has a purpose of preserving the family home, a palazzo or something, that's a purpose. But the truth is that the beneficiaries of that home are going to be the family who pass from one generation to the other. So you have a basis to look through and consider that that purpose foundation is really for the benefit of the family enjoying the right to live in it. So, there's a discussion about substance on the issue. Okay, going to family offices, which is one of the novelties of the trust bill, Malcolm will discuss some of these aspects.
Yes, we've really just started to discuss this in Malta. I'm fortunate that I've come from jurisdictions where we've operated some family offices for some significant families, and we've also set up private trust companies. Just going back just to one point that Gary made then, we did discuss about purpose trusts, and we had a lot of discussion about it. And the trouble is, it's one of those things that's very much associated with offshore jurisdictions. So that tainting was something that we decided we didn't want to attract to Malta. So that was why we leaned in the end against it. So, which we'll see why that's a problem when I go into one of these other slides. So the important thing is, like in a lot of cases, you're dealing with diverse families and diverse financial interests, so no structure is the same for any family. The family's objectives are often in relation to consolidating the management of their interests and then controlling those interests with family input. You're often dealing with advisory teams belonging to the family and external advisory teams that are brought in as specialists. The difference is that there's always a close link with the family when you're dealing with business to do with the family, but when you're dealing with a family business, they become almost like co-trustees with you. They're sitting with you. They're far more involved and far more active. And obviously, the weight of their interests, there can be a lot of difficult discussions with trustees sometimes in that environment. Typically, but not exclusively, you can use a private trust company to hold the interests, and this is one of the aspects that will come out of the family trust proposals. The family trust proposals hopefully probably will limit the number of settlers to 5, but that's okay because really in a lot of these situations there's one main person that's developed that business and it becomes the main settler for that business. One of the aspects which is important from a family point of view is the fact that because there's a board of directors operating the private trust company, they can remove professional trustees that they fall out with a lot easier. It's removing a director. In a trust situation, obviously when you're removing a person that's the sole trustee of a trust, it becomes a retirement of appointment situation. It can be a protector removing them, but it's usually a retirement appointment. There's a lot of discussion about indemnities. It's a slow process, and it can sometimes be very irritating for a wealthy family. This gives them a far much more control in that environment. What I'm going to do is the next 2 slides, I'm not going to go in detail, but they're more just giving you an outline in case this comes up in your own practice. This is a possible private trust company structure. There's just a number of points I'd mention about this. You see at the top there's the private trust company, and above it you have a number of options for ownership. Normally in jurisdictions such as Bermuda, particularly because Bermuda developed the purpose trust, but BVI came and you'll find a purpose trust, but equally you could use a foundation, which is obviously something available in Malta, and for a lot of civil law clients, they're used to that. Foundations have been around in Europe a long time, and they've been used at the top of a family structure. So that's something we have available. We obviously have the charitable trust. The other two very common and more novel solutions internationally are the Vistra Trust from BVI and the Star Trust from Cayman. Coming down, so you have one discussion about ownership. You have the other discussion about the constitution of the board of a private trust company. And that's usually where the most discussion takes place. There shouldn't be a line to the beneficiaries that floats out to one side, because there's lots of ways in which this structure develops wealth, and then the wealth can be distributed. So there's lots of options depending on the family grouping. Maybe different family members have different interests in different aspects. So you sometimes can have a separate distribution structure, but in this example, you could quite easily have family members being distributed from Trust 1, Foundation 2, or Trust 3. In this example, I've done the normal thing of trying to stream the things according to their different risk. You've got investable assets. I've worked with situations with two brothers where one brother looked after the industrial side and the other brother looked after all the investment side. You've got another aspect, often the property you want to keep separate because different exposure, different risks. So that's the general kind of outline of a private trust company. And the other kind of takeaway that I'm giving you, which kind of dovetails with this process, is that if you are dealing with a large family, very wealthy family, maybe 30 to 100 million type family, whatever, sterling or dollars, usually the family wants one point of contact to their own family office. And you can see the multitude of different aspects that a family office will be dealing with. This is a family office without a PTC. And they're dealing with investment management, wealth transfer, tax services, family meetings, all the administration of the family. And you could have this family office dealing with a private trust company. And you may have the managing director of the family office as a director of the private trust company, and then some of these tasks falling under the private trust company. So that's just an example of the kind of complexities that you're trying to deal with for a family.
Okay. Next issue is, in Malta, we need to deal with notaries. There are lawyers and there are notaries. It's not the same profession. And with regard to trusts, notaries normally don't feature in the world of trusts, but they feature a lot in the world of foundations. So when the trust project was launched in Malta, there were ideas in terms of taking advantage of the fact that we do have notaries. And notaries are a very important part of our legal system. They provide for a lot of attentive research and establishment of facts. They provide for a lot of authenticity. And therefore, they were introduced within the trusts project. And Annalise will just tell us a few things about it.
Primarily for the benefit of foreigners, the notaries we have in Malta are the civil law type of notaries, okay? So we are all basically giving public face. There's the two-pronged nature of our profession, okay? So we're the professionals and also giving public face to documentation. Now, as Max correctly said, trusts in Malta can also be set up via notarial trust deed. So we have a possibility of opting for a non-licensed trustee, all right? So the trustee would not be licensed, would be a person who falls within the criteria laid down by law. So primarily a relative, someone who knows the settlor, okay? And provided they go through the notarial procedure, they can opt to set up what we call a private trust. Now, this was also something we tackled, I say we as a notarial council with MFSA, and we came up with these legislative proposals The idea being not to create second-rated trusts in Malta. So we have on the one hand the trusts that are created via the intervention of professional trustees, and on the other hand when we have non-professional trustees. So these are created through a notarial trust deed. And we are proposing better rules in relation to the registration, conservation and access to these deeds. So the notary features throughout this procedure as being a publishing notary, so publishing the actual deed, the depository notary. So whereas in a normal professional trust scenario, you'd have the trustee conserving the documentation and having the obligations by law to conserve all the documents relative to the trust. In relation to a private trust, okay, it is the depository notary who would be the plenipotentiary of this role, would be the person entrusted to keep under lock and key these documents, which could be very important at a later stage, let's say for their probatory force, should anything arise in relation to that trust. So yes, with these legislative proposals, we are seeking to enhance these rules, and we've proposed rules in relation to conserving the confidentiality of these deeds. So typically, I as a notary would register, we conserve our deeds in volumes, okay, in books. Now we couldn't have a situation of a notarial trust deed being conserved alongside, let's say, a deed of sale. So we've come up with a proposal of having each notarial trust deed bound in separate volumes, and this would obviously ensure confidentiality and control the access to this trust deed. The depository notary, as I already said, will be ensuring the conservation of these documentation, and we also wanted to make sure that there would be a higher authority above the depository notaries who's aware of who these depository notaries are. And basically, the notary to government, the authority by law that oversees the operation of notaries in Malta, would be updated with a list constantly of the notaries having these documents relative to trusts. So, God forbid something happens to a notary, we know who to turn to see who is the actual holder of the documents relative to a particular trust. We've clarified also the accessibility rules. So how can you get access to an inter vivos trust which is not held at a professional trustee's office? Will we be ensuring the confidentiality of these trusts? Yes, we've imbued the system with security by giving a role to notaries who would actually be charged with explaining to the layman trustee, because presumably in these type of trusts, you could have a person and his brother is the trustee of his assets, so he doesn't know anything about trust law. So the depository notary will be really buttressing the situation and assisting lay people when they are acting as trustees. An important point to make is we want to ensure accessibility of trusts. And this type of trusts, private trusts, are obviously very cost effective because there isn't a professional trustee involved as well. So we don't want people with small estates not to opt for trusts because of the cost element. So if they can appoint a relative or someone they trust as a trustee, why not? We're in to promote the culture of trust and promote the culture of foundations. And this is a way to, yes, explain to a person who has a very nominal estate that a trust in his particular circumstances can serve a purpose. Obviously, we are assuming that the scenario calls for the requirement and for the need of a trust. The last point refers to the qualified person. Now, for those of you who are not familiar with trust legislation in Malta, whenever there is a dealing or a transaction related to immovable property or related to securities that are not listed on a regulated exchange, and there is a trustee who is not licensed, we would need to have the intervention of what we call a qualified person. This would basically be a person, traditionally a licensed trustee, who would ensure compliance with fiscal and with money laundering legislation. We have also proposed in the new bill for the notary, being the notary already subject to AML regulation, qua subject person of these regulations, basically the notary would be able also to step in and act as a qualified person. This would obviously be also a cost-cutting exercise in the case of private trusts.
Okay. Okay, so we've got notaries coming into the trust area, and now with foundations, we want them to get out. Because foundations are heavily dominated by notaries, because you can only create a foundation through a notarial public deed. And the issue was, do we leave the system of public registry methodologies to continue to apply to foundations, or do we upgrade it to an English law type of corporate registration system? And the decision was follow the English system showing in our company law. In other words, once you've got your public deed, you put it in a public registry, and then things that happen in relation to that foundation can be administered by the administrators without the notary. So you could file statutory forms in the public registry. You could, change the administrators without the notary, and so on. So it created a much more smooth solution to the issue of foundations, which are legal entities. They're corporate bodies. The issue of confidentiality hits us again in foundations, obviously. Where you're dealing with foundations, the question is, you've got a public deed, and then you've got some secret information, which is very similar to trusts. But now you've got a public deed. How are you going to deal with it? So the same solutions that Annalise explained about preserving the confidentiality of trusts when done by notaries has been proposed in relation to foundations. Already we have the rule that the beneficiaries do not need to be named in the foundation deed. So that already keeps beneficiaries out of the document. But the document called the beneficiary statement must be signed by the founder, and it must be kept safe, because that's obviously the core and the heart of the foundation. So the next question that comes is, okay, so what are notaries going to do in relation to this confidential information?
Even though me and Matt always have this argument about whether notaries should still exist, so I think this is coming out. And I think for those of you who deal with civil law clients, I'm sure they appreciate having us notaries around, because it adds some more. So yes, there is the pros and cons, but we do tend to be a bit too formalistic, and I think these legislative endeavors are trying to find the golden mean, the balance, as correctly stated, between being overly formalistic and being, on the other hand, too lax with forms. But yes, the beneficiary statement, correctly so, is, as said, is a very important document. I mean, as notaries, if I keep a private foundation, I do not keep the beneficiary statement. Now, what is the nature? I can keep it, but I'm not obliged to. I have to certify it, so it is signed and by myself. But traditionally, it is kept by the administrators. Now, questions arise. We are subject people from an AML point of view. How am I doing the due diligence on something which I don't? So these are the constant vexata questions coming up as we act in these confidential, circumstances, because what is the value of these instruments, particularly the confidentiality is crucial. So we appreciate the confidentiality, but we have to espouse it also with these issues. So yes, I mean, this is a problem we're facing, and what we're saying is basically, listen, we are verifying the beneficiaries from an AML point of view at setup of the foundation, but thereafter, given that we do not keep the document, it's in the hand of the administrator, so hopefully we are covered from an AML point of view.
Notaries worry that administrators will tear up the beneficiary statement and then nobody knows who benefits. So they want to hold it in their files, Anyway, I'm joking. The question of unregistered foundations pops up. A trust is done by signing a trust deed. Nobody bothers about it. It's signed, it's kept by the trustees, and you move on. What if you do this with a foundation? So you say, and I've seen these deeds. In other words, they do exist. I hereby set up a foundation. I dedicate 10,000 euros to the achievement of this purpose, and the administrators are these people. And I sign it, and I give it to the administrators, who now have 10,000 euros, which they will administer under a fiduciary obligation. What's that called? Is it a trust? Is it a foundation? Our law is very careful in terms of when a trust exists. If you do not express yourself clearly and use the word trust or something which makes it very evident that you intend a trust, you do not have a trust. When do you have a foundation? The notaries will argue you have nothing there. You didn't use a public deed. You've done nothing. You've got a mandate, an instruction to these people to spend the 10,000 euros for a purpose. Our law does, however, recognize foundations which are unregistered. because as a matter of fact, they are there, and there are administrators that are administering the money, which has been settled hundreds of years ago, sometimes even in the last century, not the one that just passed, the one before. So, you cannot get up and suddenly say, if they're not registered, they don't exist. So our law deals with that issue in order to recognize the state of fact. The next point we clash with notaries is then you want to change something. Can you do it in a board resolution of the administrators and move on in life? Or do you have to plod along to the notary and redo the deed and re-execute a deed of foundation? And this is one of the issues which the law needs to deal with. There's a negotiation taking place. In other words, if you're changing administrators, if you're changing the address of the foundation, if you're putting in the form of accounts you have to hold, if you put in a supervisory body to supervise the administrators, then do it. But then if you're going to change the purposes, then you should go back to a notary. So it's always, where do you draw the line? But these issues pop up because notaries are so prevalent in the area of foundations. These issues don't arise in trusts. But if it's a private trust, because you've chosen to use a notary, then everything has to be done because the notary is the depository of all the documents, and it is there for authenticity and safekeeping.
Not to give the impression that notaries are at loggerheads with the system. I mean, we all appreciate the need to do the legislative updates and to fine-tune to make these instruments amenable, reasonable, expeditious. We don't want to be obviously part of like cogs in a system that's not working, the notary.
So how would access work?
Sorry?
How would access to the document?
Access to the deeds.
If we had to make a parallel with trusts, how would it work?
No, technically the law stipulates that it is a confidential document, so we would need to verify that the person requesting access to the document falls within the permitted realm of people who can, similarly as trusts.
So there's the settler.
There is the settler, the administrator, or anyone expressly obviously authorized to get access.
Okay, so a third party cannot ask you to...
For a private foundation, for a purpose, it's public domain, because obviously it's a public document.
Okay.
So we can work even within the existing notarial system.
Okay, this is where the tension with the public registry pops up. You see, a public registry is there for everybody to check who the administrators are, what the purposes are, what the foundation is meant to do. Is the transaction you are doing with the foundation within its objects? So you go to the public registry and check it, like we do with companies. Now, if everything is hidden in the notarial volumes, how am I as a third party going to verify these things? So, there's a balance that has to be achieved. With trusts, you can't check anywhere. You have to deal with the trustee. You either trust the trustee, or, you simply don't have a transaction with the trustee. That is the big issue. And in our law, what we've said is that the trustee can issue a declaration which you're entitled to rely on in terms of his powers and the existence of the trust. So, given that we have a civil law institute and an English law institute, we're trying to take the best of both and trying to somehow arbitrate between which are the elements which make sense in one context and which are the elements which make sense in the other.
So you're, in a way, acknowledging an irregularity.
Yes, you are acknowledging that people can set up foundations in an irregular manner, just like our company law in 1962 recognized that there could be companies which are not registered. And the legal report said when that happens, all the directors and promoters are personally responsible. And that is what this law does. In other words, if you set up a foundation irregularly, it exists, but everybody involved is personally liable. So you try not to deny the fact, because it's there. The money has been allocated. It's been received. It's been set to a purpose. An English lawyer would call that a trust. But, our test for the existence of a trust needs greater certainty, simply because we're a bit more formalistic in the way we would treat it on hitting us.
What is worth adding is the powers an unregistered foundation enjoys. So technically, as a notary, I could have an unregistered foundation purchasing property. So we have to deal with these entities, even as entities empowered to act in the civil
Yes,
world.
probably what we would do as lawyers is insist that it gets registered.
Yes.
In other words, I'll give you 20 days, go and register, and then I'll buy the property from you.
Exactly.
Because you'd solve the issue. You'd know who the directors are. You know who you are dealing with then, because you've got a public register which can give me the information in an authentic manner. The definition of an attribution or an appropriation of assets to a purpose falls into two possibilities. It's either a trust or, under our law, a foundation. In other words, giving money to somebody to do something with it is a mandate. But if you stamp a patrimony with an objective, and then give that combined patrimony and objective to someone to administer without a mandate, in other words, then it becomes a foundation. So it's really an issue of definitions. We find these unregistered foundations with education institutes. We find them irregularly created in relation to disabled children sometimes, where fathers and mothers give the property to their children to keep and administer for the disabled child. So they disinherit the disabled child and give the other two brothers, the brothers and sisters, an estate to administer for the benefit of the other child. So these are all irregular. Now, why would you want it to be a foundation? Because if the brother and sister disappear, the heirs might suddenly claim the estate of the disabled child because there's no segregation. So arguing for a foundation which is unregistered means you protect that patrimony and make sure that as the brother and sisters pass away, the court can appoint somebody else to administer the estate for the child. And it's very, very important that we have these kind of protections, which under English law are not a problem because trusts solve everything. But we couldn't, stretch trust into the whole legal system in that way. And this brings us to the next point. When we are dealing with foundations and trusts, as you are seeing, what should the strategy be? Should we treat them as identical structures with different names? Or should we seek to identify their unique features and, albeit with underpinnings which are similar because they're both fiduciary structures, and treat them differently? Now, there's this debate going on. Should we eliminate all that is unique to trusts and all that is unique to foundations and come up with two similar entities? And the first point we can deal with is, for instance, the fiscal treatment. How would you deal with it? Should you deal with it differently or the same?
Well, ideally, from a fiscal point of view, obviously what we have to presuppose is that a person opting for a trust or a person opting for a foundation will not be barred access to certain exemptions or attenuations in the law which exist for other beneficiaries. So, for example, if I acquire directly and I get a preferential tax rate on the acquisition of my first property, is it equally accessible to me if I acquire via a trust, being a beneficiary in a trust? So we need to ensure that there is a certain degree of alignment. I think alignment would benefit from a fiscal point of view in the trusts and foundations, provided, however, they are aligned to the bigger picture. So we do not want to discriminate against the use of these instruments vis-a-vis the broader tax possibilities in other instruments applicably.
Okay, just for the information of those who don't know, foundations are taxed like companies unless you tick the box and request that they are taxed like trusts. Trusts, on the other hand, are tax transparent unless you tick the box and choose that they are taxed like companies. So there are options on all fronts, but the default rules are different. Trusts are transparent, foundations are non-transparent. When we come to the regulatory, my opinion is we should not discriminate between the two institutes on a regulatory basis. From a country point of view, the risks of the country's reputation arise in both. The potential for money laundering arises in both. The need for regulation and control of fiduciary obligations is there in both. So from a regulatory point of view, we should have a streamlined regulatory regime. Private law, what's your view?
Well, I believe they should be kept distinct. I mean, we're adding wealth, we're adding variety to the opportunities we have. So we go for a trust because it's not a foundation. We go for a foundation because it varies from a trust. I mean, we're filling in, we're really creating differences, nuances, and giving a broad spectrum of opportunities to clients doing estate planning. So to date, before 2004, we used to use of donation, succession. We were okay, but now we have more on our menu, really, and I think it's good to be kept that way, and provided there is sufficient legal backing and clarity in the law, that is why we need constant updating in the law. I think we're really lucky to be using these type of systems.
As different institutes.
As different institutes.
Okay, from the international perspective, Malcolm, what do you think? What should the approach be?
I think just taking one step back, the most important thing is obviously a foundation's a legal entity, and a trust is a relationship. That's an interesting point from a client's point of view.
As an international client, do you want to find two similar or identical institutes with different names, or do you prefer if they're different?
I prefer if they're different. They're going to have different purposes for different clients in different situations. So I think we discussed there was various areas where I saw it was good to stay with the form of a trust in a very conservative way, and then obviously looking at the foundation and its advantages as an administrator as well, in relation to the founder, in relation to the structure. It offered different opportunities, and we needed to keep those different opportunities. If we made them too similar, we would defeat the opportunities of having a foundation and probably the selling opportunities of foundations.
Okay, one historical point I can let you in on is that when the law of foundations was drafted, there was a policy decision to extend the principles of trust law relating to the protection of beneficiaries and segregated patrimonies and all this sort of stuff to foundations. And the Maltese law on foundations is the only law in the world, as far as I'm aware, which actually gives a massive amount of protection to beneficiaries. Many laws of foundations tend to look at the settler or the founder, tend to look at the administrators, tend to look at the patrimony and the purpose, but don't really speak about beneficiaries at all. So this is one of the elements in Maltese law where a policy of alignment was used to make the foundation one which is much more acceptable from a protection of the beneficiaries angle. Okay, conclusions. Maybe you can tell us something about what's been happening, on the commercial side.
Yeah, just to give you a kind of an outline of statistically how well Malta's been doing. If you look just 6 years ago, the number of license holders as authorized trustees, we were at the point of 70. You can see that there's been probably not steady growth, as we were all, our objective was steady growth, but looking at 61 increasing to 131, that's not steady growth, that's very, very good growth. If we look at this in terms of the previous slide, and you say that maybe 14 of those 131 operators are international footprint type organizations, then you've got 117 which are domestic. So even the domestic growth has been good. The one issue that I had was trying to find any statistics in relation to turnover and operator size of the industry. And I know that the MFSA, with the new reporting, this will provide, hopefully, some very, very good statistics on our industry. The one question I'm often asked, why is trust important? Because a lot of us do corporate services. But the thing is, when you look at the international operators, they do trust, corporate services, do funds as well. And the thing is, they can blend these services in delivering a total service to the client. And why trusts are important is because usually that's at the top of all the structures. And if you haven't got the top of the structure, then maybe you're not going to get the stuff below. And you're in a very key position. And as a practitioner, if I lose my trusteeship, I'm probably going to lose everything below to another competitor. And that's the same type of thing in jurisdictional aspects. That's why the trust is so important. Looking at the growth of foundations, I'm very keen on foundations, even though I'm a trust practitioner. I will also say, in relation to, obviously Max was the one that actually included the beneficiary provisions. I'd never ever seen that in a jurisdiction before. This is the only jurisdiction. And when I'm selling that to people that don't really have not really considered foundations before, they suddenly realize that's an advantage of Malta over Panama and other jurisdictions, Guernsey, Jersey, but all have foundations now. But Malta have these beneficiary protection provisions. Now, certain clients will like that and understand the benefits of that. Some clients will say that as a disadvantage, but I think most of them find it an advantage. Advisors find it an advantage. We're now at the point of 35 private foundations. At a continuing professional development evening we did probably 2 years ago, we were at 15. So in 2 years we've grown 20, and we know from practice there are some very significant foundations in those numbers. So we are getting some penetration in this area. Also, as we've mentioned about the unregistered and other foundations, The total number of foundations in Malta is around 150. So a lot of non-private foundations operating in Malta, which is a good culture.
Okay, just in case you haven't understood the point, when you are an administrator of a foundation, you need a license as a trustee. And one of the deficiencies in a way with regard to foundations is that only licensed trustees can be administrators of foundations. And that is a bit unpopular with clients. In other words, when a client wants to use a corporate entity and sees that they could appoint administrators to their corporate entity, when you tell them that you must use 3 authorized trustees or 2 or 1, because you can have 1, they keep on insisting, but why can't we be administrators as well? And the answer is because you don't qualify. You're not a licensed trustee yourself. So what we do as a solution is we create a supervisory body. It's similar to a protector within the foundation structure, and the clients can sit on the supervisory body. So they are effectively influencing and supervising what the trustee is doing, and can even be given powers to give the trustee instructions, which the trustee can obey or not obey, but you sort of keep them involved. But when we talk of license holders, we are talking of license holders authorized to be trustees of trusts and administrators of foundations.
Right, it's the requirement to have a license triggered off when you're an administrator of
a private trustee. In other words, charitable foundations and charitable trusts do not need regulated trustees, hence the concern about the AML coming in, because you don't have a subject person there. Your conclusions?
To add on to, as well to what Malcolm was saying, obviously the number of foundations also indicate the contracts being done, well, the public deeds being done by notaries, because obviously every foundation needs to be set up through a public deed. Now, apart from the statistics mentioned, there are also a considerable number of foundations in the process of being registered. So the feel we get, even from colleagues of mine, is that obviously the foundation is picking up and it's being used more and more frequently. With trust, it's a bit more difficult to get a real feel of what the number of private trusts that are being set up. But obviously, it's gaining more and more ground. Now, my conclusions really relate to the bigger picture. I mean, obviously, we've spoken about Maltese legislation, where we are to date, where we postulate to be in the near future with possible amendments in the law. We have to also remember that talking about estate planning, we cannot forget the European developments coming our way. I mean, succession, for those of you who are following what's happening on a pan-European base, we have the regulation 65 of 2012, which will be implemented in August of 2015, and this will change a bit the dynamic of succession planning, obviously with a cross-border effect, so for people having residence in one country, living overseas, really, for these international clients. So yes, we have to also bring our instruments up to date with these amendments and render them also useful in the context of developments happening, for example, with the matrimonial regimes. So yes, we have to keep updated with both local and international developments. Another point I made earlier was the importance of ensuring the attractiveness of trusts and foundations for potential clients, people using or being attracted to create these instruments by not rendering tax exemptions less amenable to them. We know that it's a tax-neutral instrument as a trust or a foundation, so you're not worse off using a trust and a foundation. That's a very important thing, especially with property conveyancing, all right, to keep these things really neutral so that we ensure the continued use of trusts and foundations.
Okay, thank you. Some remarks on my end. Unfortunately, trusts are still suspected as being tools to avoid tax and to defeat the rights of spouses and to cheat shareholders, and there is this negative perception. We've been on an ongoing battle in Malta to try to convince people that trusts are not bad things to have in the legal system, because there's a lot of negativity in some areas. Unfortunately, some cases have gone to court for good reason, and particularly in the matrimonial court, you find a lot of actions seeking to find whether property has been hive their way into trusts, because here we have community of bequests, and if you get property belonging to the spouses put in a trust, you might actually lose sight of it. The last judgment that came out about 2 weeks ago was a case where a person separated from his wife. He had a partner and wanted to buy 2 motorcycles. So he asked his partner to buy the motorcycles in her name, which she did. They then split, and he wanted the motorcycles back because they were his. And in the lawsuit, the argument was, I put them there so my wife wouldn't know about them. Literally. And the defense said, if you did that, you were immoral, and therefore the court shouldn't help you. You can't go to court with dirty hands. And the court was getting a bit confused about all this talk of morality in the context of hiding, and so eventually the court decided that the motorcycles were his, the partner should give them back, and ordered the partner to transfer the motorcycles because she was a trustee and she should transfer them back under her fiduciary duties. So these kind of judgments coming out in our courts, perpetuate the feeling that, there's something which isn't quite right with this area. And therefore, the challenge we have as a country is obviously to enforce standards continually and ensure that we do not allow people to operate within the industry if they resort to this kind of tolerance. Now, here we had a private context, but let's assume you find a professional trustee who accepts property to hide it away from, the spousal relationship. Obviously, that should disbar somebody, because you cannot tolerate these kind of things happening. As a country, we're obviously challenged with what is happening all around us. I am of the view that we should not protect the grounds of confidentiality too strongly. In other words, privacy is fine, secrecy is a difficult issue to deal with. As a country, we are fairly transparent in our tax system, in our exchange of information. These are fiduciary structures which are subject to a misunderstanding within the European Union, which is totally out of proportion to reality. So we are dealing with a problem here. People in the European Union have this very parochial view as to what these fiduciary organizations mean. In our law, we've actually given direct access to this information to the MFSA on anything at any time. So we took a very clear position that nothing is secret. It is regulated, it is governed by rules, but nothing is absolutely secret. So let's build on that. The political approach has to be deft. I think we have to jump ahead of what is happening. We always have to see what's coming next, what's going to hit the industry next, what's going to hit, from all different angles, whether it's America, whether it's England, whether it is the European Union, and make sure we read the signs of the time fast enough in order to be ready when the hit actually happens. I don't know how many of you saw the headline yesterday about our Prime Minister meeting the President of France, and the President of France acknowledging that Malta isn't a tax haven. That's the first time we had something so public which defeats the perception that Malta must be a tax haven because it's a small island and has trusts and has foundations and this sort of stuff. So my sense is that we really need to be very, very competent and careful in the way we deal with the strategy in this area. Okay, we've got literally 5 minutes. So if you wish to raise any issues, go ahead and we'll get the reactions from the speakers.
Trusts and foundations have never been an acceptable requisite for residence schemes in Malta. That means that we always said, or at least our legislation always says, that the immovable property should be owned in the name of the individual. I know there were 2 or 3 cases whereby the Inland Review bypassed this, but by and large, the property, immovable property, should be in the name of individual, and we don't generally use trusts or foundations. Is there a reasoning behind this? Can anything be done? Are there any problems or difficulties that can be raised because of this? Now, especially since our government is considering revamping residence schemes.
Yeah, your impression isn't quite correct. In other words, there is a law which prohibits non-residents acquiring property in Malta unless they go through the Ministry of Finance. Now, that has been reduced for EU citizens, and you can have one house and so on.
Under the residency schemes, the high net worth individuals, and so on and so forth.
Yes, so the
it's
issue
on
is
the
this.
personal basis.
Yes, that if you want to combine a residence permit to a property,
You have to do
the
a
government
rent
has to know
agreement.
who owns the property. When you go with a discretionary trust, the government never knows who the owner is. So the government was asking for the disclosure of the trust deed. And unfortunately, some professionals who were over concerned with confidentiality refused to give the trust deed to the government to show them who the beneficiary is, to combine the two schemes. My view has always been, you want to get an exemption, you want to get a privilege, you have to disclose the information, full stop. Don't use a discretionary trust, use a fixed trust with successive interests. But this got confused because the authorities were not able to be as deft, in terms of the way they dealt with these concepts. At the time, they were trying to enforce the law. At the time when we joined the European Union, the whole market suddenly opened up and they were getting a lot of these new inquiries. So it got a bit confused. Clearly, some amendments to the acquisitions of immovable property by non-residents needs to be done. The second point is in the trust law, there is a specific provision which allows non-domiciled residents to acquire property through a trust set up in Malta or abroad. And if you do that, the forced heirship rules don't apply to the property in Malta. Now, that is a very, very important principle. So if you have an Englishman coming to buy property in Malta, he could buy it in his own name, or he could buy it through a trust. If you do, then you look at English law for inheritance. Because Maltese law won't apply to the property in that trust, it will look at the Englishman. If, on the other hand, an Italian came, then you would look at the Italian and apply Italian law to the inheritance of that individual. So our civil law has dealt with the issue of property being acquired by non-residents. It's just that people haven't got around the opportunities which exist. And clearly we need to make it a bit clearer and talk about it a bit more so that more people can use this solution.
But in the second phase, and then if you apply for the scheme, if you apply for the high net worth, are you presenting the trust document and...
Correct. You show that you're the beneficiary of the trust, and you will qualify, that property will qualify for your residence permit. And that has happened. I mean, I know it has happened, but it takes a lot of bureaucratic argument and it takes argument, but that's because the government department is, again, like the point we had in the earlier session. In other words, we've got the law right, but the implementation of it, when you're facing with the government bureaucracy in an area which has nothing to do with financial services, then has to deal with it on the civil law level. And there you get a different level of tension and bureaucracy hitting you,